Very warm good evening to all. Today, first we will discuss what is the professional communication between the client and the ourselves, that is the lawyers. See, in our profession, sometimes the client comes to us and tells things which he or she has not told anybody or spoken with anybody. Now, these are the communications which are actually privilege and professional communication. If somebody said something to me and if I go and disclose it, it will be really very difficult to for somebody who has actually confined to me the truth. And if I go and tell another person the same thing, that will be against my professional ethics. Now here, under Indian Evidence Act, there are some few sections. Today we will take section 126 of Evidence Act. Now here it is about the professional communications. We said the litigant may come to you and may confide with you about few things which he, suppose it's an offense. He has killed somebody or he has beaten up somebody or he has cheated somebody. Now, if he comes and tell you something which is actually a very secret information, and this communication was given to you as your capacity as a lawyer. Now, you cannot disclose this to everybody. This is against the professional ethics also. Recently, we had also seen one judgment wherein the Bombay High Court had said that the lawyer cannot be forced to tell the police about the whereabouts of his clients. On the similar line, this is section 126 of the Evidence Act, little bit. We'll go through the same. This is section 126 Indian Evidence Act, professional communications. The section is very clear, but just by a simple plain reading, you will understand what is it. No barrister, attorney, pleader or vakil shall at any time be permitted unless with his client's express consent to disclose any communication made to him in the course and for the purpose of his employment as such barrister, pleader, attorney or vakil by or on behalf of his client, or to state the contents or the conditions of any document with which he has become acquainted in the course and for the purpose of his professional employment, or to disclose any advice given by him to his client in the course and for the purpose of such employment, provided that nothing in this section shall protect from disclosure any such communication made in furtherance of any illegal purpose. Now here I would like to tell you that whatever communication he has already told us, we are barred from giving it to another person. It may be a document also, but here there are few, see, provided nothing in this section shall protect from disclosure and is the information made in the furtherance of any illegal purpose. If he has beaten up somebody and he has come to you that I have beaten up somebody, now he said I will go tomorrow and kill, then that is the information you are supposed to give to the police, because it is about in furtherance of further committing a crime. So when he is going to commit, he or she, then in those cases you have to inform the police because he is telling that I will be committing the crime and which is against the society. But if he has already committed, your duty is that to protect him and put up his case before the court. Any fact observed by any barrister, pleader, attorney or vakil in the course of his employment as such, showing that any crime or fraud has been committed since the commencement of his employment, after he has met me and thereafter he commits the crime, then also we have to inform. We cannot be protected from disclosure. Suppose my client commits forgery after meeting me, after engaging me, then it is my duty. See what is the law is saying. This is very important. 126 subsection 2. That if any fraud is committed after my engagement, then also I am supposed to, I have to inform the police or the law authorities. It is immaterial whether the attention of such barrister, pleader, attorney, or vakil was not directed to such fact by or on behalf of his client. Explanation: the obligation stated in this section continues after the employment is ceased. See, after he or she has engaged me and they commit crime, and if I am aware about the same, I have to inform the reason behind that. As a lawyer, our duty is to see, defend the client, but not to help him, or not to be just a spectacular spectator, a mute spectator, I would say, to the crime he's committing. See, as a lawyer, that is why it is called a noble profession, that we cannot expect that he continues crime. See, suppose if my client has beaten up his wife, and after that also he continues to torture her, then I'm not supposed to tell him, or be a part of this same. That is a crime. Now there are few more examples. A client says to be an attorney, I have committed forgery and I wish you to defend me. As a defense of man known to be guilty is not a criminal purpose. This communication is protected from disclosure. He is just saying that you have to defend me, I have committed a forgery. This is simple. This is protected from disclosure. A client says to be an attorney, I wish to obtain possession of property by the use of a forged deed on which I request you to sue. This communication being made in furtherance of criminal purpose. See what is saying? I wish to obtain possession of a property by use of a forged deed. See, he wants to use it. We are not supposed to guide him to commit a crime. That is the meaning of this example. This communication being in furtherance of a criminal purpose is not protected from disclosure. So as a lawyer, our duty is to stop people from committing crime actually. So this section is really very important. A being charged with embezzlement retains B, an attorney, to defend him. In the course of the proceeding, B observes that an entry has been made in the A's account book, charging A with the sum said to have been embezzled, which entry was not in the books at the commencement of his employment. Employment means he has employed me, about a lawyer's employment. This being a fact observed by B in the course of his employment, showing that a fraud has been committed since the commencement of the proceeding, it is not protected from disclosure. Once the client engages me in thereafter, he further goes and makes something which is a criminal offense. Now here, if it comes to my knowledge, that is not protected from disclosure. So remember this. This is very important. So Section 126 protects you to defend your client, and you're not supposed to disclose. Even if the client go and engages another lawyer, I give no objection. He or she is protected, and I cannot easily give information to another lawyer. In fact, I would say if he has engaged another lawyer, and if we give NOC, I feel it is my bounden duty to help the other lawyer to give all the papers and anything. If I may be having any documents which is going to help him in defending his client who is no more my client, it is our duty that we give no objection whenever the client comes, and easily we tell the other lawyer this is the position. That is the why it is called a noble profession. Another thing also I would like to tell you, that you have no lien over the client's papers. I have few clients who tells me that the lawyer is not giving the papers. See, as a lawyer, if somebody has not paid your fees, you have your another avenues to go and file case against your client for recovering of your fees, but you have no lien over your files of the client. So whenever a client comes to you and if he is giving you file, I would request all of you to ask him to give only a photocopy. So even if you are misplacing it, so in the future you can get another copy. He goes to another law also, then also he can engage it easily. See, our duty is to help lawyers, also to help the court to arrive at the truth. It is not that we are supposed to here only to earn money. Earning money is one of the part of the our profession, but not the completely we are depending on it. It is called a noble. See, teaching is called a noble profession, and the same way this is also called a noble profession only for this reason. So this section 126 is one of the important sections. We may have read it again and again, but if you read it again, you will really know that how it is actually having a deep meaning. And it is deep rooted meaning, if we apply to our daily practice, trust me, we will be helping the court in having like less cases, because there will be less crime, because we can always tell client, kindly do not ever commit crime. I had a client who was just 19 years old. He was in love with a girl who was minor, 16, 17 years old. And because he was major, he was caught in POXO. And when he was in jail for 13, 14 days, when he came to meet me, he said, I will commit more crime because I have loved that girl and court has put me in the custody for what reason. But then I told him that this is not the way you should behave. And if you commit crime, I will not continue your case. And trust me, later on, he became so matured. He was acquitted of charges also because it was a love affair. It was not POXO. In fact, he was not minor. He was 19 years and the girl was 16 years something plus. So somehow I was able to convince him. And there later on he became matured. He married also. He got a girl now also. But he did not commit any crime. So it was my duty to explain that you cannot commit any crime any further. And if you commit, I will not continue your file and I will inform the police. He was 19, so he got scared of me that I will not. His father and mother also told him that madam will not continue with your matter. And that's why because he has gone to jail, so he was just 19. He was telling, I have not committed crime, why I was put in jail. But that it is your duty to, because it was very difficult for me to explain that under POXO, that girl was minor. And as you were above 18, you were actually major person. And that's how he understood later on. Now he is a matured person. So next part is the reading one. That is with Nidhi today. Nidhi, kindly unmute yourself, dear. Nidhi is going to read something
Yes.
very interesting today. There are two readings, Nidhi.
Yes, ma'am. I'm audible, right, ma'am?
Yes, you are audible. Can you read this?
Yes, ma'am. I'll just decrease the size of.
I should decrease,
yeah.
right?
Okay. No. The window, the
Okay.
videos. Okay. I'll begin. Give up movies, parlor. Dedicate time to law. Justice Pratibha M. Singh to women lawyers. Don't seek sympathy from the court. Don't tell how you will pick up your child. That stereotypes you. Be competent. Give up Bollywood movies and parlor time. Dedicate to law, Justice Singh said.
She is Justice Pratibha Singh. You can read from Delhi High Court Judge.
Delhi High Court Judge Justice Pratibha M. Singh urged women lawyers not to seek sympathy from court since it will lead to the bench stereotyping them. Justice Singh also advised female lawyers to ditch the attitude that one must sacrifice either work or family and to instead break stereotypes and devise ways to balance and multitask. Don't seek sympathy from the court. Don't tell how you will pick up your child. That stereotypes you, she said. She also called on women lawyers to devote their time and attention to law practice by cutting short time spent on going to parlors or watching movies. Be competent. Give up Bollywood movies and parlor time. Dedicate to law. Pick your battles. Don't fight with all, she said. Justice Singh was speaking on the achievements and challenges of women at the bar at an event organized by Women in Law and Litigation to felicitate Judge of the Supreme Court, Justice Hema Kohli. At the event, Justice Singh was introduced as a superstar in the field on intellectual property law. The Delhi High Court judge said that a focus on specialization rather than a sacrificing attitude is essential for women to progress in the field of law. Specialization is helpful for women. Always keep a domestic help. Always keep drivers. Don't have a sacrificing attitude. Take children with you while briefing senior counsels and make them do their homework. That is what I did during my tenure. Face the stress that may arise from that with a smile, and perhaps your child may feel, Mummy, ghar pe nahi hoti. But one day he will be proud that you are a lawyer, she said. While she had words of praise for the Delhi High Court, which she described as the most cosmopolitan court where religion, caste, and marital status are irrelevant. She did opine that the women who were designated as senior lawyers at the court often had to be worked twice as hard than their male counterparts. It is not about glass ceiling anymore. There is no ceiling. I would like to tell the judges and lawyers of Delhi High Court, thank you for believing that women are not only good for passovers and adjournments, she said. In such an environment, perhaps the pandemic has been a boon for women lawyers who can now appear virtually from home and have their own workspace, she surmised. She concluded with a reminder of how far women have progressed in the field of law, where once Justice Leela Seth, the first female judge of the Delhi High Court, was a source of wonder for the people of the country who had not seen or perhaps even imagined that a woman could be a judge. Hard work and perseverance will pay off. As we go forward, nobody will come and wonder what happened to Justice Leela Seth in 1998. She was informed that there was a group of farmers in the court who saw the zoo first and then they were there to see a woman judge. Supreme Court Judge Justice Indira Banerjee and Delhi High Court Judge Justice Rekha Palli also spoke at the event where Chief Justice of India N.V. Ramana was the chief guest.
Just a minute. There is one more reading today by you.
Yes, ma'am.
This is also about a woman judge. Started career with caste decay. Can you see?
Yes, ma'am.
Please go ahead.
Yes, ma'am. Started career with Cars Dickey as office space, Justice Hima Kohli. Justice Hima Kohli on Tuesday urged women lawyers to shatter all glass ceilings and break barriers. There will never be a right time for women to enter legal profession, Supreme Court Judge Justice Hima Kohli said on Tuesday while urging women lawyers to shatter all glass ceilings and break barriers. Justice Kohli recounted how she herself had started out with the boot of her car as her office space. Time will never be right for women in legal profession. It is now. If you don't have office space, I started my career from the luggage area, dicky of a car. Shatter all glass ceilings and break more barriers, she said. She was speaking at a function organized by the Women in Law and Litigation, WIL, to felicitate her on her elevation to the Supreme Court of India. Justice Kohli revealed how WIL was conceptualized at a roundtable dinner. We thought there are so many things we would like to share with each other and help other women legal professionals. WIL was here to help women with the kind of support we didn't receive, she said. Justice Kohli also elaborated on the difficulties faced by women lawyers since there is no old boys club or networking for women in the profession, and thus very few women have been able to establish themselves in the field. Don't be embarrassed as lawyers. Consider everyone as blocks of wood and argue before the bench. Always be prepared and don't give an impression that you are not prepared. Keep aggression in court and don't carry it home, Justice Kohli advised. She also touched upon the difficulties as a judge. It is a lonely life as a judge. It is like goldfish in a bowl. If you feel frivolous, keep it inside the four walls of your house. You symbolize the whole system and anything private should remain private, she said. Justice Kohli was born and brought up in New Delhi. She was appointed an additional judge of the Delhi High Court on May 29, 2006 and took oath as a permanent judge on August 29, 2007. She went on to become the first and only woman Chief Justice of the Telangana High Court on January 7, 2021. She was appointed Supreme Court Judge on August 31st, 2021, along with Justices B.V. Nagaratna and Bela M. Trivedi. Former Additional Solicitor General and Senior Advocate Maninder Acharya spoke about how journey of a woman in the field of law is very distinct than that of a male counterpart. Women are scaling newer peaks, but it won't be wrong to say that they are still struggling, said Acharya. Senior Advocate Acharya further added, that there is a need for a new dawn when a woman law officer or a judge will not be news and there will be a sea of women legal professionals so that the need to prefix the Mr. or Miss is obliterated. Justice Indira Banerjee of the Supreme Court and Justices Pratibha Singh and Rekha Palli of the Delhi High Court also spoke on the occasion. Chief Justice of India N.V. Ramana was the chief guest for the event. Ma'am, we can't hear you.
Thank you for reading this. You were really
Thank
lucky to read this two pieces of the articles, which were
I
really good.
am, ma'am.
And I would
Very
say
good.
all the women who are present here, they must have been inspired. And all the men also, they should also take inspiration from these two judges who were really made it big. So we should follow them. And even if we follow 5% of the same, it is more than enough. Even sometime, the easiest secret I would like to share with all of you that I don't know how much we can do, but one or two things we can learn. That is to reach court on time, one, or before time. Another, to dress up properly. And now dress up does not mean putting up lipstick and having a very beautiful attire and everything. A proper code uniform and the our whatever we are wearing band, that should be very clean. Our clothes should be very clean. That is the basic things we all can do. And if we do all this, that is more than enough. This is learning will come automatically. Nobody learned in a day. You have, and you have to another thing I would say as a lawyer, never ask that I want family court matters, I want civil court I want only high courts matter. Whatever matter comes to you, please take up. It may be out of state also. If you first 5 years try to get an experience, exposure and experience, and this exposure will give you experience. And the better to join a senior lawyer who is having some matters. He or she may be in a practicing only in the trial sites. I would say that is the best practice you can get. Now, I would like to introduce you to some words. See, English is a very important language when we go to the High Court and Supreme Court. The reason behind is not that I had been to Rajasthan High Court, I had appeared in Allahabad High Court also. They do speak Hindi, but the Hindi, the quality and level of the Hindi is very good. And sometimes the legal words we are even unable to match up with. But we can speak English, and they allow us also. And they also speak Hindi because majority of the lawyers speak good Hindi there. Even judges are, and Allahabad High Court, the biggest High Court of Asia. Not only India's biggest High Court, but the biggest court of the Asia also. If anybody is from the Uttar Pradesh, I would request all of you to visit the Allahabad High Court. It is one of the best high courts I have found. And there are most of the Supreme Court judges are from the Allahabad High Court because it's the biggest high court. I think strength is 150 plus. That is along with the Lucknow. So if you, any of you from that side, I would request to visit it whenever you go to the native place. Spend some time at Allahabad High Court. The judges are also really very good, and the lawyers are also very hard working there. Now, English is one language that we should know it, and also the local language. Once I had gone to the Karnataka, Bangalore High Court. Now here Karnataka High Court, I had a lady who was speaking Marathi. I asked her, how come you are from how can you speak Marathi? She said, I am from the, actually from Maharashtra. And after marriage, I shifted. And I said, how do you speak Kannada? She said, when my children were going to school and I was coming to the court, the FIR was in Kannada language. So says, I learned Kannada language to read FIR. See, if somebody from Maharashtra studied in Marathi medium can learn Kannada as well as English, and here we have to just learn the Gujarati little bit. I can read Gujarati. I can't write Gujarati, but I can read Gujarati very fluently. I can read Marathi, Hindi, being from Hindi medium itself. So I understand the value of the English, and some of you must have studied in English medium. But see, law is a field where the sky is the limit for learning. You are always a student. Today we will take a few words from the legal profession and try to learn. I've taken out few words. I have made a few sentences also. I'll be sharing with you. Just a minute. I'm unable to share. The first word is imminent. There is a, see, this is a legal vocabulary of 10 words I'm taking up today. I hope you can see, otherwise I'll say the word imminent. There is an imminent danger to his life and therefore registering of an FIR is mandatory in this type of cases. Now see, there is an imminent danger. Now imminent is like, it is almost coming near, he is near to danger to his life. Therefore, so the word is, there is more danger, there is, you can't use such words. You have to use one good word, that is, there is imminent danger to his life and therefore registering of FIR is mandatory in this type of cases. The next is cardinal. The cardinal point of suit is that whether it is maintenance or not. See, this is what is important, the cardinal point of the suit. सबसे महत्वपूर्ण point कौन सा है केस का? We don't use the cardinal when we speak the common English. Now, apprehension. There is strong apprehension that an FIR is going to be lodged and therefore the applicant seeks protection from this court. Whenever we go for anticipatory bail, normally we say there is a strong apprehension that an FIR is going to be lodged and therefore the applicant seeks protection from this court. Now this is an anticipatory bail when FIR is also not lodged and this police calls him up, calls her, and they feel that there is an offense going to be registered. So you can seek a protection of 78 hours, 24 hours, something like that. Now, qua statutory, the rights given to mother for aborting the child as per the court order is qua statutory. Now, see, qua statutory, I would like to tell you here, there are some laws where we have seen, in one of the sessions, we have read that there is a limit of the few weeks where after which the woman or the lady has to go to the court and ask for the abortion, that whether she can abort the child, because the child in the womb, fetus in the her womb has already taken a life after 20 weeks. So you need court's permission. But if now there is no law that after 20 weeks or 24 weeks after the medical opinion you can abort the child. Now after, if it is 26 weeks fetus, now what do we do? Now here we go to the court and court gives the order. Now there is no law, but if the court gives the order, it is qua statutory. That is similar to law. The right given to a mother about aborting the child as per the court order is qua statutory. That is the meaning. इसका मतलब ये है कि अगर कोर्ट ने ऑर्डर देता है वो लॉ के बराबर है. Opposite, it is opposite. Now to mention here that the parties to suit are from different religions. Now it will be the proper or perfect place to mention here that the parties suit are from different religions. If we do not mention, see, whenever you file a divorce petition, you have to mention that which caste they are, which religions they follow. Because for Muslims, we have a different religion. For marriage being a personal matter. For Hindus, we have a different religion. For Parsis, we have a different law, Parsi law. So it will be opposite. It's not opposite, opposite. Now, fulcrum. While deciding any public interest litigation, the fulcrum is always the good for the public. Now, the word fulcrum is very, when we pronounce it, it's really different. But the meaning is very simple. This is basic. While deciding any public interest, that is PIL, public interest litigation by the court, the fulcrum is always the good for the public. That if something is good for the public, the court will entertain it. Now see the word entertain. We use while in the court. The court may entertain my application. Now if you go, अगर हम लोग simple भाषा में entertain का मतलब समझे तो मनोरंजन. Corroborative evidence. I have been using this word a lot of time. The accused cannot be convicted on oral evidence unless it is supported by corroborative evidence. जो accused है उसको conviction oral evidence पे नहीं मिलता, because there should be some proof. If somebody comes to the court and say in deposition, he has committed a crime, but there should be some medical report. There may not be an eyewitness, right? But there should be at least medical papers which corroborates. Maybe a blood stains, or maybe a blood stain on the clothes, maybe blood stain on the weapon or something like that, even if there is no eyewitness. Next is incarceration. The 14 years incarceration is required to apply for remission of the imprisonment. Now, इनकार्सरेशन मतलब जिसको बंदी बनाया गया है या जेल की सजा हो गई है, तो 14 साल की जो सजा होती है वो होने के बाद भी आप रेमिशन को अप्लाई कर सकते. देयर इज अ वीडियो ऑन रेमिशन, very interesting one. I would request Vandana to put it in the group today and do hear it, because as a lawyer you may be given a question, you may be asked question by the common people कि कितने साल के बाद, 14 साल के बाद तो अपने आप आदमी छूट जाता है ना कोर्ट से. No, it's not that easy. There is a procedure to be applied to the state government by remission. So you have to apply. So 14 years now actually there is a 14 year incarceration is required to apply for remission of when there is a life imprisonment. Non-negotiable, very easy to understand, but we should use this word. The bail conditions are non-negotiable and need to be followed. जो bail देते हैं जब भी court, तो conditions are non-negotiable. मतलब आप उसको आप कम कीजिए ज्यादा कीजिए नहीं, एक बार हो गई तो हो गई वो. They are non-negotiable, need to be followed. Complicity. The complicity of the accused could not be proved from the material available before the court. Now, complicity here means involvement. There may be 2-3 accused. The complicity of accused could not be proved by the जो material court के सामने evidence सामने उससे उसका वो उस court में उसमें सहभाग था, उसमें वो he was involved in that crime is not proved. When you say these words complicity before the court, it is going to affect the judge also in a positive way कि बच्चा पढ़कर आया है, the lawyer पढ़ के आया है. And see, judges are also interested in knowing the good language from you, good judgments from you, the way you are representing your client, which makes a lot of difference. So this is actually very important. So I would request all of you that when you read a judgment, see how I got these 10 words. I read a judgment and took it out and made a few sentences for you to understand how to use it. So you can maintain a diary and start writing words. Even if you write 5 words each day, it will be 150 words in a month. So you understand 150 into 12, it will be how many words in a year. And if you are going to read it one judgment every day, or at least one judgment a week, and you are able to take out 5 words each day, it is going to, and 5 words are not very something which you cannot do.